Welcome to Continental Divide, a guide to Colorado divorce.
Hello, everyone. Welcome back to Continental Divide, a guide to Colorado divorce with Kristi Anderson-Wells of Wells Family Law in Denver, Colorado. A former executive compensation attorney and author of the Executive Compensation Handbook, published by the American Bar Association, Kristi brings a unique perspective to divorce, complex finances, parenting, and problem solving in Colorado family law. I'm Sean O'Connor, and today we're talking about unmarried partner breakups and the legal issues Colorado couples often do not see coming. Kristi, good to see you.
Good to see you, Sean.
And we have Ann Gushurst here. Hello, Ann.
Hello, how are you?
I am doing great. I understand you were on the team of attorneys who worked to eliminate the ban on same-sex marriage in the Colorado Constitution. Is that right?
That is correct. The anti-DOMA.
Nice.
If there is an issue in Colorado that needs a knight in shining armor, Anne is usually already on the horse, ready to go.
Really? All right.
Yeah.
All right. Kristi, why do so many couples assume ending an unmarried relationship will be simpler than going through a divorce?
I tell my children, who are all adults, that there is a reason to get married. There's a reason to get married, and that is because we have a predictable statute to guide them if they have to break up. If you are unmarried, we live in a world where the Uniform Dissolution of Marriage Act doesn't apply, and you're in civil court instead of domestic relations court, and you have to rely on all these old, antiquated common law concepts in order to divide your property. I'm thinking partition, I'm thinking unjust enrichment, maybe in quantum meruit, conversion for personal property, replevin, and what else have we got out there?
Joint endeavor, city ordinances, like different places where you live can have different rules regarding benefits and stuff like that. It's a mess.
And it's very fact specific and
judge specific.
And judge
really
specific.
Judge specific.
Agreed. So you're unmarried, you think, oh, you know what, this is brilliant. I'm just going to buy a house with this guy. Let's invest.
I trust him.
He's not important enough to me to commit my life to him, but I will commit to a 30-year marriage or 30-year mortgage with him.
It's terrible. One of my very first
mind blown.
Now, one of my very first cases, a woman came in. They have 4 kids. He was a mildly successful businessman, ran like an auto shop or something, and she was a school teacher. And after 32 years together and raising 4 kids, all the property was in his name, and she walked away with nothing.
Wow. Okay. So I think we're done here. Get married. No.
There's Colorado, right?
Colorado. By the way, I looked up palimony just because I was reading the notes for this today, and they claim that Colorado has 3 cases that have awarded palimony. So that just goes to show that Wikipedia doesn't know everything.
Not true. That's AI lies. AI lies.
But there's other reasons besides the simplicity of being able to go into one legal path. If you're not married and you love somebody, but your in-laws hate you, and your spouse gets sick, they can kick you out of the hospital. They can prevent you from going to the funeral. They can treat you like you don't exist. And there's nothing you can do.
In Colorado?
Almost everywhere.
Okay. Well,
And Colorado is one of 6 states that has common law marriage. Most of the states don't.
Well, what is common law marriage in Colorado? Assuming is it different in different states?
Well, that's a good question.
Well, first of all, so Anne's going to go into some history of common law marriage for us because she has some pretty strong feelings about how it developed in Colorado. But I will say, if a court finds that a common law marriage exists, it's a marriage, and you will be getting divorced just like other people get divorced under the Uniform Dissolution of Marriage Act.
Okay.
And tell us how you get to common law marriage historically and in any relationship.
Okay, historically, the common law states tend to be the Western states. because during the time of the formation of the country, it was very difficult to get married in like the Badlands of South Dakota or the Great Plains, right? So people who lived in what they call, marriage like unions would, marry. Technically, under a lot of religions, spouses marry each other. It's a contract between the spouses, right? And that's true of a lot of traditions. And it's only more in the last 200-300 years that the state has involved itself, mostly in preventing people from getting divorces, but also in granting them occasionally. In any event, it was because you couldn't legally get a marriage.
There might be no judge. There might be no judge for hundreds of miles, and the circuit court judge wasn't going to come around for the next 6 months. You know,
Right.
and you're knocked up. What are you going to do? You're on the frontier, knocked up. Come on.
Right. So, I mean, and gradually most states have moved to get away with it. And Colorado probably will do that. It works a real disadvantage to somebody who's given up their career or been disadvantaged having children or supporting somebody else who's taken the lesser paying job and has nothing in their name. And yes, there is a long sordid history in Colorado, because if you look at the last 4 reported cases, 3 of them are a Supreme Court case. And one of them was the Court of Appeals case where a guy who had been 34-year-old sleeping with a 14-year-old charged with statutory rape said, "You can't charge me. I'm married to her." And and the court held that the age of consent under common law is 12, but said 0.
What year was that?
I think it's 2006.
But you also have the protection against spouses testifying against each other. So it's
Yeah,
super
well,
convenient to claim a common law marriage if you've committed a crime and you don't want your partner, Clyde doesn't want Bonnie testifying against him. They're not really married, but Clyde says, "Hey, we're common law married in Colorado." So she can't testify.
The current case now, that was the law. That was the law that was set out, because most of these cases previously where people would die and the person who's been living with the guy says, "Hey, I'm his wife. I should get his insurance or his pension or whatever." There's a whole series of insurance cases looking for death benefits. Anyway, Lucero was a criminal case where they held that the common law wife couldn't testify against the husband. And then we have Hogshead, which unfortunately was my case at the appellate level, not at the trial level, but I mean, it was a crazy case. They thought they were married. They entered into a separation agreement. They filed for divorce. The court administrator, who is supposed to have 0 authority, says you can't get divorced because you're not married. And then the court found that there was no marriage when the agreement turned out to be unenforceable.
And Hogshead was a same-sex couple, right?
Mm-hmm.
And was this before or after the change to the Constitution?
It was after the change to the Constitution.
So in Colorado, what are courts looking at to determine if there's a common law marriage? What are the factors that are going to swing the day? Well,
there used to be in Lucero, there were a set of factors. And basically what the Hogshead court said was, we have to relax this set of things that we had for regular couples who are heterosexual, because a lot of them will not apply to same-sex couples. Calling somebody your wife and your husband. Well, you can't do that for 2 women. You can't say wife and husband and husband. Other things would be, beneficiary status on insurance policies and things like that, because a lot of insurance companies wouldn't allow it. But the other thing they said, and this is the holding that blew my mind and makes it almost impossible for me to talk about this without losing my mind, is that you have to have a sincere belief in the institution of marriage. And I have to tell you that I have yet to meet somebody going through a divorce who will say, "Yes, I sincerely believe in the institution of marriage." It's like,
right.
What?
But we get people coming in all the time that say, "We've been married 10 years. Do we have a common law marriage?" No, you have to have held yourself out as married, as Ann was saying. This is my husband. This is my wife. My husband and I lived together for 10 years before we got married. And every time a waiter would say, "And what would your wife like?" He would say, "My wife would like XYZ." And of course, I'm a lawyer. So I would say, "I'm not his wife." Because why? You could get caught out in Colorado if you don't deny it. You could be found to be his wife. Oh, I got the waiter from the Red Lobster here, and he says you didn't deny it when he called you his wife.
Right.
So there was holding yourself out as married. There was joint ownership of property. There was insurance documents. There was tax documents. The biggest problem with common law marriage was you could have all of the factors under Lucero. You could have them all. And you could even have a sincere belief in marriage. You could take it in front of a judge and you'd be like, I'm an amazing attorney and I've got all the factors. I've got all the facts. I've got all the evidence. I've got all the witnesses. And the judge would say, no common law marriage. Similarly, you could go to court with no factors. You're fighting a common law marriage. There's no joint ownership of property. There's no holding out. Like the Christmas cards didn't say Merry Christmas from the Smiths. The Christmas card said Merry Christmas from John and Susan. No joint property, no holding out, no nothing. And the judge could be like, well, you had a baby together, so you're common law married. And you just be like, there's no law that says having a baby together makes you common law married. So it's completely unpredictable in Colorado whether you're going to win that argument or lose it based on the law that we have right now, which makes it very difficult. I mean, I have to advise every client that comes in the door, like, great, you got 6 factors, but I can't guarantee you're going to win it.
It just
Literally,
is it up to the discretion of the judge? I'm sorry, Ann. I mean, is it just depending on the judge? And which is true in any scenario potentially, but more so here.
No, if you have a marriage certificate, they have to accept that.
Well, yeah.
But like if you look at the Hogsett case, the test is, did they believe that they were married and hold themselves out to third parties as married? These parties,
both of them
filed a divorce action and then signed a separation agreement, and the court found that there was no marriage.
Yeah, it's crazy. It's the Wild West. Common law marriage, Wild West.
All right.
Well, Ann and I have this fight all the time because I say, I don't want my clients to accidentally find out after they've been with someone for 10 years living in a house together that they're married when they didn't think they were. And then now they're going to owe maintenance when they never, I mean, there's an engagement ring, which means they aren't married. But like they were like, sure, we'll get married someday, but they didn't get married. I don't want my clients being accidentally married. But Ann has a different perspective.
Well, because I've represented so many, and they're predominantly women, or I've represented probably half a dozen gay men who've been in marriages where the other party was much older. They lived together. The other party paid for everything. And then when they got to a certain age, they were like, yeah, I need somebody younger. And in one case...
Wait a minute, who said that?
I've had both. It's always been men who've said that. And I don't want to sound sexist, but that's the way it's been.
No. Who said they needed somebody younger? The older guy or the younger guy?
The older guy.
Okay.
Yes.
Wow.
Come on, Sean.
I'm sorry. I thought that was obvious. But anyway.
I'm learning too here. This is,
and in one case, it was 4 kids later, and they'd done everything together. The families were totally integrated. They had theoretically marital estate of a couple $1 million, and she left that relationship in her 50s with nothing. For para. She had her para, so it's not nothing. And then there was one I can't tell you the facts because it would be known, but they did everything they could to be married, but it was pre-Obergefell. And it just, and I still don't know how that ended up turning out.
So pre-Obergefell means it was before the change to allow same-sex marriage. And I will say this, the moments that Ann almost wins the argument with me are the ones where she refers to people who are in a same-sex relationship. They've been together 20 years, and because of the change in the law, they were able to get married. And then there's a discussion of what happens to the 20 years before the date of marriage where they were living together, creating a house together, an estate together, raising children together. How do we treat the 20 years before there was legal marriage for same-sex individuals?
Yeah.
And I mean, without common law marriage, you have potentially a 25-year marriage with only 5 years that counts. And
I think I'm tracking Kristi on that, but maybe some people listening aren't. So the scenario you just painted, let's say, okay, my partner and I are together for 10 years and then post law change another 5. What are the ramifications of that first 10 or 20 years being sort of like where does that show up in the divorce, I guess?
Okay, so you're living together as a married couple. You come here, you have no ability to get married, and then here you have the ability and you go forward. Well, first of all, most people get stuck in their relationship and don't sort of say, oh, there's this obscure case that passed. Now we have to go get married. It's the same relationship from their perspective.
Yeah.
But let's assume that they do get married here and then they go forward. All this period of time, if you don't count them as being married at common law, and this is the exact discussion we had at the Family Law Executive Council. Everybody's like, oh, I hate common law marriage. It's so hard, blah, blah, blah. It's like, yeah, okay. We finally just got in Colorado the ability for same-sex people to get married. And a lot of these people have been living together for 20, 30 years. And now you're saying that they have no recourse for the first 20, 30 years. So everything you've bought and everything you've put together and your entitlement to support is based on paying.
Maintenance, alimony in Colorado is based on the number of years you were together. That's one of the factors.
Oh,
So if you're only going to, in a 25-year marriage, if you're a 25-year relationship, you're only going to count the 5 years since marriage was legal. You are severely reducing the spouse who's got a maintenance claim's ability to get a living maintenance claim.
And also half the property, right? Because it's all.
I was going to say there's
separate.
assets, right? To be split or not split.
Right.
Well, all right, this is fascinating, and I did not know coming in that it was going to be. So thank you both. There's a few minutes left, and it's like, okay, so again, we've got people out there listening. They're on the edge of their seats, like, oh my God, what do you recommend they do? What conversations should they be having or planning? Unmarried couples, right? So
they should have a cohabitation agreement.
Agreed, 100%. And if you don't want to be married, your cohabitation agreement can say there's no chance we can ever be considered married unless we go through a formal marriage with a state-sanctioned marriage certificate. And then you've eliminated common law out of the living together. And you can include things about what happens if we decide to break up. How will the house proceeds be divided? Will we sell it? You can include a lot of contractual stuff in there that will avoid you falling into the morass of common law case law.
Real quick, is a cohabitation agreement similar to a prenup in terms of what you can put in it? But obviously it serves a different purpose in this case. I mean, similar purpose, but.
Okay, so there's two major differences. One is that premarital agreements are covered by a statute and they have certain requirements for disclosure and legal representation. So that's a big difference. Okay. And two, a lot of people don't draft cohabitation agreements. That's a bigger problem, in my opinion. But people need to understand, if they are in a situation where they're not protected by marriage, common law or otherwise, and they've got property, here's what this looks like. In a divorce, you trot down and you file a motion with a judge. He's going to hear your custody. He's going to divide your house and he's going to divide up your property. Mm-hmm. But if you don't have that, you file a motion in district court for custody. You file a motion in small claims court for replevin, which is getting your goods back. And you file a separate action for partition in court of equity to divide your house.
Oh, my God. Okay.
Yeah. Right. And if you're lucky, your attorney knows how to do all three of those. Otherwise, it's really expensive.
Wow.
Well, and even if they do know, it's really expensive.
It is. Because things like dividing the house, a partition action requires that the house be sold, but that each party has to prove their contributions to that house. So you've got like potentially years of tracing financial contributions to that house that both sides are going to have to undertake.
Yeah.
And that's just a really expensive proposition.
And if you have a business, then you have labor claims, which is a totally separate thing, federal court. And you have, you do joint endeavor and quantum merit and all that in just enrichment. And like I had one case where there were 4 separate actions I had to file. And let's just say that made one of my partners very nervous because I had never done 2 of them before.
All right. Well, we are out of time, which happens, but thank you both. And thanks for showing up again. Always great to see you. Kristi, same. It's your show. You kind of have to show up. But really great to see you both, and I look forward to talking more in the future. That's it for today's episode of Continental Divide, a guide to Colorado divorce. If you'd like to learn more about Kristi Anderson Wells and the team at Wells Family Law, visit their website, wellsfamilylawcolorado.com. This podcast provides a general overview of a legal topic and should not be considered legal advice. If you need advice regarding your specific situation, please contact an attorney. Thanks for listening. I'm Sean O'Connor, and it is always helpful if you leave a review or share a link or subscribe. Helpful for the program, helpful for others to find it. Have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.